When people come to the United States illegally, often it's because they come from very desperate situations. They can't afford to financially support their children, and so they sneak across the border hoping for a better life. Well, they get trapped in the end when they have a child or someone who's willing to sponsor them for a green card, and immigration determines that any act from their past when they brought a child across, once they had the money to send for the child, is actually an act of smuggling. When people think of smuggling, they think of a coyote who has an elaborate system of bringing 10 people across the Rio Grande, and they don't realize that smuggling itself, besides being a criminal issue, is an immigration bar to any kind of green card and affects even basic family members who are just trying to bring across a son or a daughter. So for instance, if you were filing a green card case and you're a US citizen adult and you're filing for your parent, and she brought you across when you were 5 years old, or she paid a coyote to bring you across when you were 5 years old. When she gets to her green card interview, they're going to ask her how you got into the country. And they're going to find out that she was a big part of that, and they could charge her with smuggling, which is a ground of inadmissibility which would deny her green card. However, smuggling does have a limited waiver available. It is filed on Form I-601, but it is very different from the type of traditional waivers that are filed on the 601, such as the 10-year bar or the misrepresentation waiver. Those waivers require that you show a qualifying relative would suffer extreme hardship and that the waiver is deserved by the immigrant. In contrast to that, a smuggling waiver requires only that you were smuggling across an immediate family member, a son, a daughter, a spouse. It can't be a step-parent, it can't be a brother or sister in order to get the smuggling waiver. So you have to show that they had this familiar relationship to you, they were your son or your daughter at the time that you did the smuggling, and that you have an immigrant visa available for you, and that it would be in the public interest to allow you to come in and waive that past sole act of smuggling, or it would preserve family unity. And preserving family unity, what has typically been interpreted to mean is if you have, let's say, 4 or 5 US citizens in the United States who are close to each other, a close family, and mom is the one who's going to be stuck outside by herself, then that would be an argument that you would use, that you want to reunite the family, that everyone needs mom's help and that mom is going to be suffering on her own if she's not allowed to get this waiver approved. Lastly, you can also show that for humanitarian reasons, mom's waiver should be approved. Again, these are not defined clearly with factors that the courts are going to look at. They're very fact-specific types of waivers. But if you're able to show family unity, if you're able to show humanitarian reasons, or it's otherwise in the public interest to allow mom to come in, get her green card, and waive that past act of smuggling, you also have to show that mom deserves it. It is a discretionary waiver. So if mom has a lot of criminal past, or if she has had numerous immigration violations besides the smuggling, if she's lied to get a green card or lied to get access into the United States, if she's been deported before, that kind of thing, those will definitely count against her in being able to win over on the discretionary basis. But don't take smuggling for granted. We've seen cases from other attorneys where they filed I-601A provisional waivers for mom because of mom's unlawful presence and didn't really think about, well, go back in time, did mom ever help their son or daughter, the person who is sponsoring them now for a green card or someone else in their life, did they help them smuggle across? You don't want to get a provisional waiver approved and then send mom to the consulate and she has to file another waiver but may not have the qualifying relative to do so. So you need to ask those kind of questions up front before anyone files anything. I am an expert in complex family-based immigration cases and have a 98% approval rate for the past 12 years. I am a nationally published immigration author and frequent public speaker on immigration topics. I regularly train other immigration lawyers on complicated marriage and family immigration cases for the American Immigration Lawyers Association, Federal Bar Association, and national legal education providers. I represent clients all over the U.S., traveling to immigration interviews and deportation proceedings. Visit our website, humanrightsattorney.com, for more in-depth information and articles on complex family immigration issues.